Good afternoon, everyone. Welcome to our Title IX Team Meetup. I'm Kendra Yoch. I'm the host of our Franczek PC podcast, Education Law Insights. For any first-timers here, TEAM, T-E-A-M, means Title IX Educational Administrators Meetup. And this is a monthly gathering where we come together to discuss all things Title IX. This week, as has become a bit of a pattern, we're going to be talking about changes under the Biden administration. Joining me to talk about this issue is Jackie Wernz. Jackie is an editor and frequent blogger on our Franczek Title IX Insights blog. And as a former OCR attorney herself, she has been keeping close tabs on the changes to Title IX we've been expecting from the Biden administration since day one. Welcome, Jackie.
Thanks, Kendra.
All right, if you have any questions during our live webinar recording today, please don't hesitate to use the Zoom Q&A function, and we'll do our best as always to answer those questions. Okay, so although we planned these Title IX team meetups in advance, we couldn't have picked a better day to hold it this month. Just this morning, we received big news from the U.S. Department of Education's Office for Civil Rights, or OCR. And so let's start here. Jackie, what did we find out this morning?
Right, so Kendra, we did get some big news from OCR this morning. Today, Suzanne Goldberg, who's the acting assistant secretary for the Office for Civil Rights for OCR, issued a letter saying that OCR will conduct a comprehensive review of the department's Title IX regulations, the ones that just went into effect last year. And that in this letter, she outlined ways that members of the public will be able to participate in the decision-making process about what to change in those rules.
Okay, so people have been speculating that the Biden administration is going to jettison the Trump Title IX rules since even before the election. So why is this information a big deal at this point?
Yeah, so we knew that President Biden would want to get rid of the rules, but we weren't sure how. So if you have been following our Title IX Insights blog, you know that I've had a number of blog posts on this topic since the election. And in some of the blogs that we posted right after the election, we laid out the many possible ways that we thought the Biden administration might use to get rid of the Trump rules. And now what we know from this letter is that the administration doesn't intend to challenge the regulations in court or to try to get rid of them through some, complicated method using Congress or some other backdoor manner. That they are signaling to us that they are going to use notice and proposed rulemaking, that they're going to publish a notice in the Federal Register of the intent to amend the existing Title IX regulations. And then that act will open up many additional opportunities for public comment.
Okay, so give us a little background for anybody who might need a refresher. How did we get here?
All right, so I know for most of you, I see a bunch of familiar names on our live recording here, and I know that you've all been here since the beginning, so I'll keep it pretty short. But as you all know by now, the Trump administration issued a new rule implementing Title IX of the Education Amendments of 1972, which is the law that prohibits gender discrimination in schools. And this was a big deal because there hadn't previously been any regulations in place, any formal rules from the Department of Education that specifically addressed sexual harassment in schools. And so it was a really big deal. These new rules took effect in August. And according to President Trump and at the time, his Secretary of Education, Betsy DeVos, these rules were really intended to give more clarity to everyone involved in Title IX sexual harassment investigations and processes in school. And then also really importantly, to give more due process right, more fairness to the parties, and particularly to the accused in campus sexual harassment and sexual assault complaints. Now, very quickly, victims' rights advocates criticized the new rules on many, many points, including its narrower definition of sexual harassment and a narrower geographic scope for when schools would be enforcing sexual harassment rules under Title IX. Now, from literally the first days of the presidential campaign, then candidate Joe Biden made very clear that he intended to get rid of the rules if he won. But it's a lot harder than it sounds because the Trump team did something that no one else has ever done before, which is that they put in place their changes to Title IX through formal regulations after going through the notice and rulemaking process. And that made it a lot harder under previous administrations. Changes in civil rights processing and how OCR dealt with complaints was typically done through more informal methods like guidance and executive orders. But these rules are law, and so they generally can only be changed if they're overturned or amended. Now, Biden did sign an executive order last month, and I know you've all read about it on our Title IX Insights blog, but just to summarize there, Biden did sign an executive order last month that directed the education secretary, who's Miguel Cardona, to review and consider rewriting the regulation. But as we explained on our blog at the time, the order really didn't say how the Biden administration intended to change Title IX. And so as a result, it really didn't warrant any practical changes for schools, colleges, or universities. Rather, it just directed Secretary Cardona to consider suspending or revising or rescinding the 2020 Title IX rule, but it didn't actually take any action with respect to that Trump rule. And it did also say, hey, Secretary Cardona, you can issue new guidance interpreting the rules, but it didn't provide any new guidance at the time either. So this press release and this statement from OCR is important to me because it really signals the first step in that process. And in it, as I mentioned, OCR has really signaled that it plans to use rulemaking to make its major changes to the rules.
Okay. So remind us of what that process is for rulemaking for any out there who aren't administrative law nerds like we are.
Yeah, so basically what happens is that initially the Department of Education, or whatever the agency is that is responsible under the law for issuing the rules, will draft the rule, and then it will publish it in a proposed form to the world and allow people through the notice and comment process. They give notice of what the proposed rule is, and then they give some time to submit comments, and that has to be at least 30 days. After the comment period has ended, there is a post-comment internal review. And at that point, the agency here, the Department of Education, has to comb through all of the comments and respond to them. And then you get a final rule that is published once the department has taken into consideration those comments.
So to put that in perspective, how long did this process take for the Trump administration when it issued new rules?
A long time. So we don't know exactly when the Trump administration's Department of Education started drafting the Title IX rule, but presumably they would have jumped on it not long after Trump took office. And so that was January 20th of 2017. The proposed rule was issued on November 29th, 2018. I'll always remember that because it was right after I came back to the firm from working at OCR. And I thought, wow, they've given me a lot of work to do. That's great. So that was almost 1 year and 10 months after Trump took office. So we can make assumptions about the amount of time that it took to write the rule based on that. It might not have taken that whole time, but that's at least a window. Now, the final rule itself, so after the comments were allowed to be made and rolled in, the final rule was issued 1 year and 5 months later on May 6th. And so the reason for that is that, as I mentioned, the department had to wade through and to respond to nearly 125,000 comments. And that ended up with over 2,000 pages of commentary. So where the department says, this is what some commenter said, and here's what we think about it, and here's what changes we made or didn't made to the proposed rule based on them. And so that was all completed. And so that took 1 year and 5 months. And then the rule itself became effective 100 days later on August 14th, 2020. Now, if we use the same time frame, that would lead to a proposed rule on or around February 6th of 2023, a final rule on July 6th of 2024, and an effective date of October 14th, 2024. So that would be, just like the last time, a mere weeks before the next election, which is scheduled for Tuesday, November 5th, 2024. Now, the Biden administration could find ways to speed that process up. And I personally think that they will. I think they'll be making this a priority because the goal is you definitely want to get the thing in place before you leave office. But man, is it scary to hear that we may be living with these rules until right up before the next election. And guess what? If the party flips again, we could go through the whole process all over again. So definitely gives me a little bit of a stomach ache just thinking about that.
Yeah, going to keep everybody busy for a really long time. So the Biden administration is going to begin the process with a public hearing, which is the step the Trump team did not use, right? So how does that affect this process?
Right. So it's going to be potentially an even lengthier process because what they've said in this statement that was issued is that they are going to have a public hearing to enable those who are interested to share their views through oral comments and written submissions. And that is before the notice and comment process starts. So before the drafting of the rule begins, right? So what they've said is that they want to give a chance to students and parents and school officials and advocates to weigh in before they offer their proposal for how these schools are going to need to respond to sexual assault and harassment. And then also there was a mention that students and faculty would be issued questionnaires meant to provide a broader picture of how the rules that are in effect right now, the 2020 Trump rules, how have they impacted the handling of sexual harassment? Now, this is actually a good thing. I think many of us would like to be able to give feedback. I know I personally am working to try to do so in every way that I can. But it does create sort of a specter of lengthiness because the department hasn't announced a timeline for the hearing. They did say that they plan to share more information and details in the next week or so. So hopefully this process will move along quickly and won't just add more length to the process. The hearing is going to occur over several days, and it's going to include a virtual component. That's according to reports that NBC News is making. And then after the hearing, the department will then begin by drafting a rule and go through that notice and comment period.
Okay, what kinds of changes might we expect to see in the proposed rule?
So you guys hear me talk a lot about, we've been reading the tea leaves since November, since the election. We've been trying to figure out what might go, what might stay. It really is, it's a guess right now. The Education Secretary Cardona, has not said what changes will be proposed. There haven't been any leaks. We don't really have a lot of information, but I think it's going to be pretty complicated. And let me give you one example. So one of the issues that many of us have had concerns with, and I know all of you out there who have been doing this process, you've probably realized why, is the cross-examination component of the rules. So for K-12 schools, the example I like to give is that if a teacher sexually assaults a 5-year-old student, that technically there is a requirement that that student submit to written questions from the teacher in the process. Now, there's some wiggle room in K-12 for maybe being able to get around requiring those answers, but it is part of the rule that is an expectation. And then in higher ed, it's even broader. So in higher ed, the requirement is that the school offer live cross-examination opportunities to the parties. And so the reason that that is a big deal is that survivors' rights proponents have said, you know, this is really going to lead people not to feel comfortable making complaints because they don't want to have to be cross-examined. They don't want to be confronted by an advisor for the other party with the other party sitting in the room, you know, or in a Zoom room staring at them. So we would, I think, imagine that many of us would be against including those requirements in any future rule. But the reason I say it's complicated is because both before and then subsequent to the issuance of the 2020 rules, some courts have recognized that, at least in the higher education context, that live cross-examination is a due process right, a sort of fairness right that the accused should receive before having their education potentially ended. And so it's less clear whether the department will follow the lead of those courts. Even if they don't, if you're in a jurisdiction where one of those courts is ruled that way, you'd still have to offer cross-examination. So it could create this really interesting hodgepodge of requirements across the country if the department went that way. So potentially, in order to keep a little bit of coherence, they might keep that in, even though it's something that I think many of us in the field don't think is appropriate.
Okay. So given that this is a really long process, should we expect any changes or updates before the new rule is finalized?
So the statement that was issued did say that OCR plans to issue a new questions and answers document in the coming weeks.
One of our favorite things. What do you think we can expect from that?
Yeah, so we saw the Trump administration do this in September of 2017, if my memory is correct, shortly after Trump took office. I remember I was working at OCR at the time, and the first thing we heard about it on the front line was the same time all of you heard about it, which is that it was released. And it was a Q&A document, and it rolled back some of the things that previous Obama era guidance had required. So for example, that was where we first saw a rollback from, hey, all schools have to use a preponderance of the evidence standard to, well, you can use that or you can use clear and convincing. We also saw there the first rollback to say, you know what, you can use mediation for sex-based harassment complaints, which previously the Obama administration and frankly, way back to the George W. Bush administration had dissuaded schools from doing. So we've seen this before. It is a method for an agency to chip away at a rule or at guidance that it doesn't like by sort of chipping around the edges of the rule without implementing a new full-scale rule. And so, you know, maybe we'll see some of that chipping away. I mean, the big difference is that when Trump used the Q&A, Trump was only responding to informal guidance. So he was responding to informal guidance with informal guidance. Here, the department would have to be more careful to make sure that any interpretation it's providing still likely is going to have to comply with the language of the rule. And we might see lawsuits challenging the authority under federal law for the administration to make any changes that kind of, you know, really go above and beyond what's in the rule, because technically you can't use informal guidance to change a rule. So, you know, I don't know what we're going to see in that Q&A, but it'll be very interesting to see what they give us, and then also to see how do particularly those who are accused rights advocates and organizations, how are they going to respond? Another thing is that in the executive order that the Biden administration issued in March that said, hey, you know, Secretary Cardona, you should take a look at these rules and figure out if you want to change them. They did mention additional enforcement actions. So the executive order from the president said to Cardona, consider additional enforcement actions to enforce the new administration's position on Title IX. And that jumped out at me. For any of you who read our blog post on that, I thought, what does that mean? Does that mean that the Office for Civil Rights is going to be taking a different position when investigating Title IX complaints, even before it tells us what that position is? So I'm very hopeful that this Q&A is going to be used as an opportunity by OCR to tell us and to tell all of you what the expectations are, because I've seen it before from my own experience of living through an administration change as an OCR attorney, that sometimes it doesn't work like that. Sometimes OCR just decides in the middle of an investigation that it's going to take a different approach. And that is really hard for the educational institution that is being investigated, because how are they supposed to know how to defend themselves if they don't know the standards? So fingers crossed that we will get through some Q&A soon. You and I were talking before when we were prepping. It seems like they're just constantly saying, we're going to change it. Something's going to come soon. Hopefully this Q&A will be finally, okay, actually, here is what we want you to do.
Right, some actual substance that we can work from.
Right.
So in the meantime, in practical terms, what should schools, colleges, universities that are subject to Title IX, kind of what's the road plan at this point?
So you guys, I feel like I sound like a broken record, but I'm tapped in enough in this community and talking with people, across the country who are thinking about this, that I at least feel comfortable that this is what everyone is saying, that you have to continue to focus on compliance with the rules as they are written. This is not an opportunity to stick your head in the sand and hope that, well, Biden's just going to get rid of the rule. Because if you were listening to that timeline I told you earlier, we could be living with these rules almost through the end of this administration. Hopefully we won't, but we could be. And so it's really important. The most reasonable thing for you to do is to stay the course, to keep implementing the 2020 Title IX rules as they are written, unless and until the department tells us something otherwise. And even then, even if they do come out in this Q&A and tell us, you don't have to do this, you don't have to do that, I really want you to be thinking with your legal counsel about whether any new informal guidance that conflicts with the rule, that's the law on the books, is going to adequately protect you from legal challenges from those who may prefer the Trump rule, at least until a new rule is in place. And so it's really more important than ever that, particularly if you receive an OCR complaint or if you receive a complaint of sex-based misconduct in your institution, that you be working with counsel. We can do things like reach out to OCR, to the great folks who work at OCR Chicago, for example, who are wonderful, and at least try to get some information about, they do give technical assistance. So to try to get some information, if you get a really tricky complaint that you want to make sure you handle correctly, we can use those relationships to try to glean whatever information is available about what positions the agency is going to take on a matter before you put together your own response. And that's really true with respect to LGBTQ plus issues, where the department has taken a much more concrete policy action to date under Biden.
Okay, and that's a good segue into our next topic. Amazingly, the indication that new Title IX rule is on the horizon is not the only big news that we have on the Title IX front this week. And it's only Tuesday. Sometimes it's hard to keep track. The Department of Justice also issued a memorandum yesterday addressing Title IX. So tell us about what happened there.
Right. So this was issued, as you mentioned, from the Department of Justice. And so just as a little primer, if anyone's wondering, wait a second, I thought OCR was who we were worried about when it comes to Title IX. OCR does generally enforce Title IX, but they do share jurisdiction for enforcement with the Department of Justice and with specifically the Civil Rights Division. And the Civil Rights Division, those are litigators. They go to court, whereas OCR, they're investigators. They do sort of internal investigations, but they do both enforce the law. And so what the Civil Rights Division thinks about Title IX is important for us to at least pay attention to. And so what happened is that the DOJ's Principal Deputy Assistant Attorney General, that's a mouthful, but it's Pamela Karlan, from the Civil Rights Division, issued a memorandum addressing the applicability of the Supreme Court's recent ruling on Title VII, where the US Supreme Court said Title VII applies to discrimination based on sexual orientation and transgender status. And what this memorandum said from the DOJ is that, hey, we are putting out there that we think that the Supreme Court's interpretation applies equally to Title IX, just like it does to Title VII. Now, Title VII, as I know most of you know, is a federal law that prohibits discrimination in employment, including based on sex. It's not limited to sex, but it includes sex. And in the case, which is Bostock, the US Supreme Court held that the language of Title VII, which prohibits discrimination because of sex, is broad enough to cover discrimination based on transgender and sexual orientation status. And the court went to great pains in Bostock to say, we're not interpreting any other law, including Title IX. And the dissenters in the Bostock decision raised a lot of concerns that they felt that application of the Bostock ruling would be problematic if it were applied to Title IX. Because of things like sports and facilities in schools that are generally sex segregated under Title IX.
Okay. So give us some more background on Bostock and the potential application to Title IX.
Right. So the Trump administration really robustly argued, literally until the last days that Trump was in office, that Title IX does not prohibit all discrimination based on LGBTQ plus status in schools. And so even as late as January 8th, so really literally the last days in office, the Trump team issued a lengthy memorandum where they said, yep, you know what, Title IX maybe it applies if you're treating someone differently, like you're disciplining someone more harshly, or you're not allowing them to do the same, classwork or something because they are homosexual or bisexual, or because they are a transgender individual. Okay, fine. We'll acknowledge that that is prohibited by Title IX, but we won't acknowledge that Title IX applies in cases where, for example, biological sex is traditionally used to separate students. And so, for example, in assigning students to sports teams and in using facilities in the school building, so restrooms and locker rooms. And what they said, and this again, it's in January, is the Trump OCR would not consider different treatment based on gender identity or sexual orientation in those cases to be discrimination based on sex. And then on day one in office, the Biden team came in and said, nope. They issued an order on January 20th, which, although it didn't address OCR directly or education directly, it did mention Title IX, and it showed that the administration has a very different interpretation of Bostock. And what they said there is that under Bostock's reasoning, that all laws that prohibit sex discrimination, including Title IX, prohibit discrimination on the basis of gender identity or sexual orientation. And it was a broad interpretation of Bostock that really contradicted what was presented by the Trump administration, even up to that last memorandum in January.
Okay, so for this newest memorandum that was just issued yesterday, how does that fit into this overall picture?
Right. So, I see it as just kind of one more clear suggestion that the Biden administration is going to be rejecting this idea from the Trump administration that there's some types of discrimination against individuals based on sexual orientation and transgender status. That's okay. But that said, if you look pretty closely at what the language is in the memorandum from the DOJ, it really just says, well, Title VII used because of sex and Title IX uses on the basis of sex. And we think that's the same thing. So there's no question to them that Bostock applies. They said 4 appellate courts have agreed that Bostock applies to Title IX since the case came out. And they said that there's nothing persuasive in the text of the statute, in legislative history, or in case law to justify departure from Bostock's textual analysis and from the Supreme Court's longstanding direction to courts to interpret Title IX's text broadly.
Okay, so what sort of practical impact does this have? Is just this shift in perspective have for schools with respect to Title IX? I know we're seeing a lot of states coming out with rules about transgender athletes, and this is becoming a hotter issue. So where do we think this is going?
So I think that this is setting up for a challenge between the federal government and state governments and schools about this issue. I'm not sure we're at the point right now where I would say you need to change course necessarily, because I think it's important to also look at what the memorandum didn't say and what the executive order didn't say. So it doesn't come right out and reject the Trump administration interpretation that there are some situations where discrimination against LGBTQ plus individuals will be acceptable. And so the thing is that they actually do say in the memorandum that if there are that whether there is discrimination based on sexual orientation or transgender status is going to necessarily turn on the specific facts. And so they say this statement doesn't prescribe any particular outcome with respect to enforcement. And I think that's important because, you know, is there still some room for the department to, you know, to recognize that some distinctions are okay? Maybe. But if you look back at how the Obama administration handled transgender issues, for example, access to bathrooms and locker rooms, there was no question that back then it was, you got to give access on equal terms. And so I don't know why we would expect anything different from the Biden administration. It's just very interesting to me that they haven't just come right out and said it.
Yeah, for sure. All right, so we've covered a lot here. Thank you for joining us. Please join us for a live webinar. Our next Title IX T.E.A.M meetup will be Tuesday, May 4th. You can also always catch our replay on the website, which is franczek.com, as well as on our podcast, which you can find wherever you listen to podcasts. And please also make sure you're subscribed to our Title IX blog. We provide more insights on these issues, and there will be more in the coming days and weeks. Thank you so much.
Bye. Thanks, everyone.